Patil sir, this is Sujata Patil. We are waiting for the Naidu sir. He may join within, I think, 3 to 4 minutes. Let us wait for a while and we'll start. Okay.
Patil sir, namaste. I'm Amit Pai.
Yeah,
I'm,
yeah. Amit Pai, welcome to Navrachana University.
yes, hello ma'am. Hello ma'am.
And Patil sir, this is Amit Pai. He is advocate on record.
I'm here. I'm practicing in the Supreme Court.
Supreme Court, and his association with us is since from last year, and he had been for the last Moot also. And Patil sir, this is a brief introduction about Amit.
Namaskar sir.
Yeah. Amit will wait for a while because
Yes, no difficulty. No
yeah,
difficulty.
just
Yeah,
2 to 3.
no difficulty.
Okay.
Yes, no difficulty.
Okay. Patil sir and Amit Pai, can we start? In meanwhile, I think Naidu
I
sir.
just had a word with Naidu sir. I think he's joining in a minute. I think he's just having some connectivity issue.
Okay,
I
okay,
think if you just wait for about a minute, I just had a word with him on the phone.
fair enough, fair
I
enough.
think within a minute he will.
Okay, if it is a
I
minute,
think he's refreshing the system or something like that.
okay, okay, okay,
Yeah,
okay, okay, we'll wait.
yeah. Just 1 minute. Just 1 minute.
Okay.
Naidu sir has also joined.
Vadodara, will you welcome? Sir is joined.
Yes, ma'am. Yes, sir.
So good afternoon, sir.
Very good afternoon.
Good afternoon. Welcome, welcome to Navrachana. Shall we start?
Yes, sir. So, with your due permission, shall we start with the mood?
Yes, sir.
Please
Please,
go.
please.
Yes, sir. Yeah, the participants are here. The volunteer can just quickly in a minute will tell you the rule and we'll quickly start. Yes, thank you, sir.
So the rules for the competition are you are given 20 minutes each team plus 2 minutes for rebuttal. Please strictly adhere to the time limit. The time you can see it on the top left corner of the timekeeper. Sir rebuttal is allowed in this round. Each mooter must speak for a minimum of 5 minutes. If you're referencing yourself, you may only use the team codes that have been allotted to you. You cannot disclose your names or the names of the college or the university that you're representing. The participants must keep their camera on throughout the oral rounds. Your audio should be on mute when the opposing team is speaking. And please ensure that you have a stable connection and your devices are fully charged. The direction of the judges and the court masters must also be strictly followed. And if you have any query, please clear it now before the round begins. Does anyone have any query? Then with the bench's permission, we may start with the round.
Yes, please.
Warm greetings to the bench. This is the council representing the appellants in the case of Alpha Pharma Private Limited versus State of Hima Pradesh and Control of Patents. Would your lordships require for a brief perusal of the facts?
Yes, please.
Much obliged, Your Lordship. Your Lordship, Tongso is a semi-nomadic community and a dominant tribe in the state of Hima Pradesh. The appellant is a pharmaceutical company whose scientists, upon researching the Eastern Ghat areas, were amazed by the properties of berry leaves as an energy booster, Your Lordship, and procured further information from the tribes. Upon extensive experiments, the company developed a tablet called Novak and was granted a patent for the same. Following its success, the company entered into a contract with the government of Hima Pradesh to set up a unit. An NGO named Unnati began uproar by the public, alleging commercial exploitation and misuse of traditional knowledge of the indigenous community, Your Lordship. A post-grant opposition was filed by the NGO and the same was accepted by the respondent, that is the Control of Patents, which led to the revoking of the patent, Your Lordship. As a result of this, an appeal was filed by the company before this honorable court. Further, the company also filed a writ petition against the cancellation of the contract by the government in a press conference and the resulting damage in its reputation, Your Lordships.
Yes.
The Honorable High Court of Hima Pradesh clubbed the two petitions and framed two issues in the concerned matter. The first issue will be dealt by the Present Counsel in 11 minutes, Your Lordship, and the second issue will be dealt by my co-counsel in 9 minutes, Your Lordships.
Okay.
Your Lordships, it is humbly submitted by the Council that the appellants have approached the Honourable Court under Section 117A of the Patent Act and the Article 226 of the Constitution of India, Your Lordship. With the Lordship's permission, the Council would like to move on to the arguments advanced.
Yeah, please.
Much obliged, Your Lordships. Your Lordships, the first issue is whether the invention of Novak medicine satisfies the test of patentability under Section 3 of the Patent Act or not, Your Lordships. Your Lordships, the Council will be dealing with this issue in 3 limbs. Firstly, the maintainability of the petition. Secondly, the drug satiates the test of patentability. And thirdly, the implementation of equitable benefit sharing mechanism, Your Lordships. Your Lordships, moving on to the first limb of my arguments, that is the maintainability, Your Lordships. Intellectual Property Appellate Board was abolished with the introduction of Section 11, subsection K of the Tribunals Reforms Act 2021, Your Lordships. Thus, applying this to the Section 117A of the Patents Act, the appeal under this section challenging the order or direction of the Patent Office would lie before the High Court, having the territorial jurisdiction over the appropriate Patent Office, Your Lordships. Thus, the appellants have approached the court rightly, and therefore the petition is maintainable, Your Lordship.
Yes.
Your Lordship, Your Lordship. Now, moving on to the second limb of my argument, Your Lordship, that is the drug satiates the test of patentability. Your Lordship, the test of patentability has 3 elements to it. Firstly, novelty. Secondly, inventive step. And thirdly, industrial applicability, Your Lordship.
Yes.
Your Lordship, novelty translates to new, and that only new inventions deserve patent protection, Your Lordship. The invention to be patented must be somehow different from all published articles, known techniques, and marketed products, Your Lordship. Drawing assistance from the case of Raj Prakash versus Mangatram Chowdhury, the court held that the essential thing is that the inventor was the first one to adopt it. The principle, therefore, is very simple. Every simple invention that is claimed, so long as it is something which is novel or new, it would be an invention, Your Lordships. Thus, even though the mechanism of the drug is similar to the traditional knowledge, Your Lordships, the very action of changing the form of drug here is novel, Your Lordships, and in addition, the enhancement in the effect adds to the novelty, Your Lordship.
No, but what is the novelty? Can you explain what is the novelty?
Much obliged, Your Lordship. Novelty is a new character,
No. What is the novelty in this case?
Much obliged, Your Lordship. The novelty in this case is the drug itself, Your Lordship. It was a tab in the form of a tablet which has enhanced efficacy, Your Lordship, of the stamina boosting effect and property.
But isn't that the quality? Isn't that the quality of the medicinal value of that particular this thing before you made it a drug?
Much obliged, Your Lordship. Your Lordship, by bare ingesting of the plant, Your Lordship, that is the berry leaves in question, the same effect cannot be achieved, Your Lordship. Here there is an increased bioavailability in the drug, Your Lordship. That is, the effect is the component is made to reach easily to the site of action, thereby enhancing the effect of the drug or the effect of producing the energy boost tremendously, Your Lordship.
And on what basis do you say this? Is it not the traditional use also of the berry plant?
Much obliged, Your Lordship. The traditional use is merely by ingesting the leaves, Your Lordship, by eating the leaves on its own, and then there is clearly given in the proposition that there has been an enhanced efficacy in the effect, Your Lordship. That is, the stamina has been increased tremendously. That cannot be achieved just by applying the principles of the berry leaves, Your Lordship.
Okay.
So if you read the Moot proposition paragraph number 4.
Please, Your Lordship.
Yes.
There itself that it has been made clear, the team of scientists that is along with Dr. Saman amazed to see the properties of the berry leaves as an energy booster. That already that particular thing was already there.
Please, Your Lordship.
Then
Your Lordship,
only that he has enhanced. There is no new thing.
Your Lordship, the traditional knowledge itself is eating the berry leaves, Your Lordship. Here, the drug has been made, Your Lordship. There's a new form that has been given to the drug, and enhanced efficacy is given, Your Lordship. So it is easier and comfortable to ingest, Your Lordship. And the making of a drug involves many other steps than just ingesting the leaves, Your Lordships.
So what
And
is the new invention so which has been made by that doctor?
Much obliged, Your Lordship. The invention here is the form of the tablet itself, Your Lordship, and the increased in efficacy in the drug, Your Lordship.
No, he extracted from the leaves and then he has formed it in a, that is a medicinal form.
Much
That's
obliged,
all. What is
Your
new invention?
Much obliged, Your Lordship. Your Lordship, if it was merely taken from the leaves and then incorporated or changed into a form, then the
So
efficacy.
that's why you read section 3 again.
Much obliged, Your Lordship.
Yes, section 3.
Much obliged, Your Lordship.
Yes,
Section 3 of the Patents Act, Your Lordship.
yes. Because whether it satisfies.
Please,
So
Your
what
Lordship.
is to be satisfied there?
Your Lordship, the Council seeks 10 seconds to open the Patents Act, Your Lordships.
Yes, yes.
Your Lordships, Section 3 is in relation with what are not inventions, Your Lordship. If Your Lordship could direct the Council as to which subsection Your Lordship's referring to.
Look at J, look at P.
Much obliged, Your Lordships. Your Lordships, the subsection J in question, we are not patenting the plant or
P.
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 Much obliged, Your Lordship. Your Lordship, there is no duplication of known properties of traditional knowledge, Your Lordship. Here, if there was a mere duplication, then the same effect would have been achieved, Your Lordship. But here is an enhanced effect in a different form, Your Lordship. So this cannot be construed to be duplication of a single component or components of the traditional knowledge, here being the peri leaves, Your Lordship.
Very well.
Okay.
Much obliged, Your Lordships. Your Lordships, in accordance with Section 13 of the Patents Act, prior art can be broken down to two essentials, Your Lordship. Firstly, any specification filed for obtaining a patent in India or elsewhere, and secondly, published in any other document, Your Lordship. Your Lordship, any other document in this reference is the Traditional Knowledge Digital Library, Your Lordship. The database of the digital library is selectively shared only with the control of patents in India now, and with 16 other patent offices beyond the territory, Your Lordships. Thus, the traditional knowledge of peri leaves and its properties is unknown to the public and the rest of the world, Your Lordships. The grant of the patent to the appellants initially by the control of patents suggests that the knowledge of peri leaves might not have been documented in the digital library, Your Lordships, indicating it wasn't a prior, it cannot be brought in the realm of prior art, Your Lordship. Alternatively, it raises concerns about the control of patents potentially acting in a negligent or arbitrary manner, which raises questions about their accountability and which consequentially impacted the decision in the revocation of the patent, present, Your Lordships.
Yes.
With this, the Council humbly submits that the drug Novak is novel and does not fall under the realm of prior art, Your Lordships. Moving on to the second element, Your Lordships, the drug lacks inventive step. Lordship's inventive step is defined under Section 2, subsection JA of the Patents Act. The Council breaks down this definition into two parts, Your Lordship. The first part being the technical advancement of the drug. In the case of Danpat Seth versus Mill Plastic Crates Limited, the High Court of Himachal Pradesh held that even a process involving an inventive step is an invention within the meaning of Act, and so it was not necessary that the product developed should be totally a new product, Your Lordship. Even if the product is substantially improved by an inventive step, it would be termed to be an invention. Your Lordships, the knowledge procured from the tribe was in relation to the plant as a whole. The tribe consumed the plant not knowing the localized effect of the plant, but rather that it simply has energy boosting benefits to it. It is the researchers of the company that strenuously tested the plant and narrowed down the effect to rather enhance in the leaves, Your Lordships. They further researched on the leaf, and by implementing and following different biotechnological, pharmaceutical, and scientific methods in creating a drug called Novak, which is not only easier to ingest, Your Lordships, but also has an enhanced effect on stamina. The Council emphasizes on this point by drawing comparison with a very similar case of Jivani drug, Your Lordships. The Kani tribe held the knowledge of the fruit of a certain plant to have energy boosting and vitalizing effects on the human body. A group of researchers, in interacting with the tribe on the same, procured the knowledge and further researched on the entire plant itself, Your Lordship. They found that the leaf has enhanced effect and strong effects in comparison to the fruit, and thus made the drug Jeevani from the leaves, Your Lordships. When the novelty of this drug was questioned, it was
Counsel, may I just make a suggestion? I'm sorry to break your flow. Would you like to state your points quickly because you're losing out on time?
much obliged, Your Lordships.
Just quickly state your points so that we can go to the next speaker, so that you don't lose out your time.
Much obliged, Your Lordships. Lordships, moving on to the non-obviousness of the nature, the obviousness is decided by the prior, obviousness to the person skilled in the art, Your Lordship. Here, any other farm, it cannot be held reasonable to think that any other researcher or pharmaceutical company could have obtained the information on perry leaves, Your Lordships. It is the skill, expertise, and the individuality of a particular group of researchers to have asked the right questions and gain the trust of the tribes, thereby understanding, interpreting the answers obtained in making a drug, Your Lordship. Your Lordships, the same was given in the case of Pope Appliance Corporation versus Spanish River Mills Limited, where it was given that merely because another person can possibly or anticipate the invention does not mean the invention cannot be patented, Your Lordship. The other person is not taken an action, and only when the action is taken can it be given importance rather than the mere anticipation of the action, Your Lordship. Lordship, moving on to the third element of my first limb, that is the industrial applicability and utility. Your Lordship, it's evident that Novak has become a best-selling drug, best-selling medicine, and he made a huge profit in just a matter of 5 months, Your Lordships. This points towards the demand of the drug. Your Lordships, the drug is based on the effect of stamina that it gives, Your Lordship. Your Lordship, any disease, disorder, or issue with the body ultimately leaches away the stamina from it. Therefore, the stamina cannot be construed to be trivial, Your Lordship, but rather it is very important, and therefore the demand and the utility is high, Your Lordships. And Your Lordships, talking about the industrial applicability of the drug, the perry leaves are important to make the drug, Your Lordship. However, there will be no exhaustion of the resources because the council proposes an ex situ conservation method, Your Lordship, which is also given in Section 36 of the Biological Diversity Act, which means that the germplasm or the genetic material of the plant can be taken elsewhere and artificially produced, Your Lordship.
Counsel, I'm sorry to interrupt. I think you can wind up because your co-speaker's time is being eaten away on.
Much obliged, Your Lordship. Is the last submission in the council will wind up.
Thank you.
The council, the last limb talks about the implementation of equitable benefit sharing mechanism, Your Lordship. There should be a counterbalance between the resources that are present in Indiana, being one of the 17 mega diverse countries, and also the protection of the tribals, Your Lordship. And thereby, a common benefit sharing mechanism is proposed by the council, and it was also used in the Jeevani drug, Your Lordship, where there was a buyback mechanism that was used. So it is practical and can be implemented, has already been done in the state of Indiana, Your Lordships. And the council at the last submission would like to connect this particular equitable benefit sharing with the principle of utilitarianism by Jeremy Bentham, Your Lordship, where the action at the end is fair, then the very action is good for the country, Your Lordships. If Your Lordships have no further questions, the council would like to leave the.
Yes. Second speaker can speak.
Much obliged, Your Lordships.
Much obliged, Your Lordship. Lordship, this is the second speaker here to argue on the second issue, being whether the company is liable to get compensation for the arbitrary cancellation of the contract. Not, Your Lordship, it is humbly submitted to this honorable court that the company is in fact liable to get compensation for the arbitrary cancellation for these 4 particular reasons, Your Lordship. One being that this writ petition is maintainable in this honorable High Court.
How is the writ petition maintainable?
Much obliged, Your Lordship. Your Lordship, in prior times, Your Lordship, the Supreme Court had a procedure of giving a more favorite stance or a favorite litigant stance to the government in issues like this, Your Lordship. However, in recent times, the situation has changed, Your Lordship. And recent judgments, especially the ABL International Limited versus Export Credit Guarantee Corporation of India judgment, analyzed a long line of precedents in order to determine the fact that Article 226 petitions regarding contractual rights against state are indeed maintainable in the High Court, Your Lordship, and they laid down particular guidelines, Your Lordship. The guidelines that were laid down are whenever there is an appropriate case regarding an instrumentality of state arising out of contractual obligation, being maintainable. Here, Your Lordship, we would like to establish that there does in fact exist a contract between Alpha Private Limited and the government of Himachal Pradesh, and therefore the first criteria is satisfied because there does in fact exist a contract. Secondly, Your Lordship, we would like to submit that merely because some disputed facts of question arise for consideration, the same cannot be used to refuse to entertain a writ petition. Your Lordship, here the question of whether the traditional knowledge was exploited, the question of the patent, the question of whether biodiversity exists, the Supreme Court has laid down that while these questions exist, the same cannot be used to just merely dismiss a writ petition, Your Lordship. The same can be considered. However, it has been urged that the same shouldn't be the only reason to dismiss a writ petition, Your Lordship. And here also, as we said,
But
while
for you to
questions
get
of fact remain,
compensation, you must lead some
much
evidence. How
obliged,
can
Your
you lead
Lordship.
evidence in a writ petition?
Much obliged, Your Lordship. Your Lordship, in regards to that, Your Lordship, there is a judgment that held that any writ petition claiming damages were also maintainable, Your Lordship, and based on that, counsel is seek to persuade this court into admitting this writ petition based on that precedent, Your Lordship. The reasoning used was simply, first of all, Your Lordship, if given the opportunity, counsel will be able to establish the grounds in the as to why we're claiming compensation, Your Lordship, because this writ petition also has a public law element attached to it, that is the constitutionality of the action taken by the government. Here it was arbitrarily cancelled, Your Lordship. That is one other limb of counsel's argument, which is
No,
that
if you, no, Mr. Counsel, if you contend that arbitrarily, so one more
Much obliged,
provision
Your
is
Lordship.
there under the Patent Act, under chapter that is 19. An appeal provision is there, appeal to
Much
appellate
obliged, Your
board.
Lordship.
So whether you have
Much ob-
gone there,
Much obliged, Your Lordship. Your Lordship, this petition is in regards to the contract being cancelled arbitrarily, Your Lordship. In regards to the patent, the appeal was filed prior by my co-counsel had spoken on that. The appeal was filed. The High Court had ordered for the clubbing of both the petitions, the writ petition and the appeal petition, in order to have both heard together in the High Court, Your Lordship.
no, appellate board, appeal to the appellate board, not
Your
to the High
Lordship,
Court.
is Your Lordship referring to the Intellectual Property Appellate Board, IPAB, Your Lordship?
Yeah.
Yes.
Your Lordship, to the knowledge of counsel, that board was it was abolished in recent times, and it was held that wherever the IPAB was put, those were to be replaced by the words High Court, and the High Court was what could entertain such petition.
Yeah. Yes,
Further,
yes.
Your Lordship, this petition that was clubbed was in regards to also the contractual obligation that were not fulfilled by the government, and that the arbitrary cancellation had violated the rights of the company. Therefore, we are seeking damages for the such breach and termination of contract on such arbitrary grounds and the violation of principles of natural justice, Your Lordship.
Okay. You proceed.
Much obliged, Your Lordship. Your Lordship, we would like to further point out that this petition, there's a case, Your Lordship, Ajay Hasya versus Khalid Mujib Sarwari. In this, the Supreme Court held that the state should act within the ambit of rule of law and would not be allowed to conduct itself arbitrarily in its dealings with the public and would be liable to judicial review, Your Lordship. Your Lordship, what counsel is contending here is simply that in any decision taken by the state, it should follow the rules given, and it must also act in a non-arbitrary manner. That is, when it is not in line with Article 14 and when it violates other laws present, the same would be liable to be nullified via judicial review, Your Lordship. And here we would like to contend that this was not in line with Article 14 because this action was taken arbitrarily without giving an opportunity for the company to present their side. And it's also important that this violated terms of the Indiana Contract Act, which as they had breached the contract, Your Lordship. Further, Your Lordship, counsel is contending that Article 14 is established to protect us from both legislative and administrative tyranny, Your Lordship, and the Supreme Court has shared the view in the past. It has been held that even executive action must not be exercised arbitrarily and must have the authority to law of support it, Your Lordship. Here, there is no authority of law to support any action taken by the government, Your Lordship, and there is no particular law in which was cited as the reason, nor were they giving us an opportunity to explain ourselves, nor have they presented their side properly, Your Lordship. They called a press conference and arbitrarily announced that they were cancelling the contract with no particular grounds at all, Your Lordship. Therefore, this is arbitrary and as a gross violation of Article 14 of the Indian Constitution, Your Lordship. Further, Your Lordship, there is no clear evidence to back what they're
Sorry
claimed,
to
Your Lordship.
interrupt you, Speaker 2. The allotted time is exhausted. Please take permission from the bench. Proceeding further.
Your Lordships, may counsel
Could you
please
wind
have a
up
few
in
more
about?
minutes?
Could you wind up in about a minute?
Much
Yeah,
obliged,
please
Your
wind
Lordship.
up in 1 minute.
Much obliged, Your Lordship. Your Lordship, Council would like to further move to the last content that this particular case is the state is estopped, Your Lordship, and by promissory estoppel, they have to we're entitled to claim damages, Your Lordship. Your Lordship, the Supreme Court case of State of Bihar versus Majid that established that, like other contracts, government contracts are also governed by Indian Contract Act, along with Article 299, Your Lordship. So clearly that in this contract also, since the contract was of a normal nature, it is important that this particular contract be fulfilled by the government, and for the breach of the same, damages are possible, Your Lordship. Promissory estoppel governs in regards to when one person has asserted a promise and made a representation, they cannot renege on the same, Your Lordship. And it has been held that public bodies are as much bound as private individuals to carry out the representation and facts and promises made by them. And the other people have altered their position based on the promise made. So whenever there's a damage relating to them, they are entitled to claim damages. And the same was upheld in Century SPG and Manufacturing Co. Limited versus District of Municipality of Ulhasnagar in the Supreme Court, Your Lordship. Therefore, we would like to contend that on the grounds of doctrine of promissory estoppel also, damages are possible. And under Section 73, damages should be given. Your Lordship, if Your Lordship may permit, may counsels go to prayer.
Yes.
Much obliged, Your Lordship. Your Lordship, wherefore in light of issues raised, arguments advanced, and authorities cited, it is most humbly prayed before this honorable court that it may, on the basis of prior foregoing the written submission, and be pleased to adjudge and declare that 1. The invention of Novak medicine satisfy the test of patentability under Section 3 of the Patent Act of 1970. And 2, that the appellant is in fact entitled to claim damages for the arbitrary cancellation of the contract, and or to pass any other orders of this honorable court deems fit and proper in the circumstances of the given case and in interest of justice, equity, and good consciousness. And for this act of kindness, the appellant shall be duty bound and forever pray, all of which is humbly submitted.
Yes. Thank you.
Much obliged, Your Lordship. May counsel step off?
Yeah. Please.
Much obliged, Your Lordship.
Yes, next.
Your Lordship seeks permission. Counsel seeks permission to speak.
Yes.
Yes.
Your Lordships, this is the counsel appearing on behalf of the respondent in the present suit.
Yes.
If Your Lordships is well versed with the facts of the case, may I please continue with the issue in hand?
Yeah. Please.
Much obliged, Your Lordship. Your Lordship, issue number 1 is regarding the maintainability of the jurisdiction, and the issue number 2 is regarding the revocation of the patent under the Section 3 of the Patent Act, which will be covered by me, the speaker number 2. And the issue number 3, which is regarding the termination of the contract by the government of Hima Pradesh, will be covered by my fellow co-counsel, speaker number 1. If Your Lordship may agree, may I please resume with the arguments of the first issue?
Yes.
Yes, please.
Much obliged, Your Lordship. Your Lordships, we certainly agree that this Honorable High Court of Hima Pradesh does have the jurisdiction to entertain any matter of importance. But the question is whether the present suit...
When you say any matter of importance, I'm so sorry. When you say any matter of importance, under what jurisdiction do you say any matter of importance? There has to be some specified jurisdiction, right? Could you address directly that?
Indeed, Your Lordship. Here I'm emphasizing on the Article 226. Your Lordship, may I continue?
Proceed.
Indeed, Your Lordship. Any matter of importance, but the question is whether the present suit does come under the ambit of the matter of importance or not. Your Lordship, the counsel for respondent humbly contends that the present suit is not a matter of importance and therefore is not maintainable in this honorable court. Your Lordship,
Ms. Counsel, do you say that the jurisdiction depends on the importance of the matter?
Your Lordship, the jurisdiction in itself is connected to the importance. I would not say the completely we are backing on this point. Further in the arguments, I'm explaining the grounds on which the jurisdiction can be applicable in this matter. So if you may permit me, I will explain those grounds.
Please go ahead.
Indeed, Your Lordship. These are the grounds on which the present matter could have been entertained are as follows. Firstly, your lordships, there would have been a legal wrong. Over here, no legal wrong has been suffered by the petitioner, as all due procedure was followed in the cause done by the respondent, and everything was done on the merits of the facts and most importantly on the public interest in itself. A company, being an artificial entity, cannot file a writ petition as contended in the case of Indochina Steel Navigation Company Limited versus Jasjeet Singh, additional collector of customers and others. Your lordships, we do not propose to consider the merits of this argument, as the appellants it is a company and is not entitled to claim the damages as stating that their fundamental rights have been infringed. Even in the case of Tata Engineering and Locomotive Company versus State of Bihar and others, that states that association cannot claim fundamental rights guaranteed by stating that the individual working and owning the association are the citizens of Indiana. Your lordship, the petitioners have also invoked section 117A of clause 2 of the Patent Act, which states that an appeal shall lie to the appellate board from any decision, order, or direction of the controller of patent under section 15, 16, 17, 18, 19, 20, subsection 4 of the section 25, and so on. Here, there is no mention of the subsection 2 of section 25 of the Patents Act, which is applied in the present case. Thus, the appeal is not maintainable under section 117A of the Patent Act. Your lordship, this leads to my third contention that the petitioner has not yet exhausted the alternative remedy. The petitioner should have approached the commercial court first, because plea with regards to the patent petition has to first go to the commercial courts. Even after the abolishment of the Intellectual Property Board in the year of 2021, the authority of jurisdiction to hear the plea with regards to patent petition has to first go to the commercial courts for the speedy delivery of the justice and to reduce the burden of this honorable court. But the petitioner has directly approached the honorable court and has not followed the hierarchy and clearly wasting the time of the esteemed bench of this honorable court. The Delhi High Court, in the case of MEB Infrastructure Developers Limited versus South Delhi Municipal Corporation, upheld the single judge decision, ruling that the appellant cannot use Article 226 to invoke writ jurisdiction, and disputes should not be resolved through the Contract Act and civil proceeding in the commercial court.
Counsel, I think we're missing the point here. They are attacking through a writ proceeding your arbitrary cancellation of contract. It is the arbitrariness.
Indeed.
Right? Arbitrariness is clearly something that the High Court under 226 can delve into.
Indeed, your lordship. The question that you are raising will be covered by my co-counsel, but to give you just a gist of that, the current writ petition lacks merits as it is baseless as well as hypothetical in nature, as the petitioner assumed that their fundamental rights were violated. But
Article 14 is a fundamental right.
Indeed, your lordship. But there's this legal maxim which I would like to state, which is named as intelligible differentia, which my co-counsel will be further explaining in its arguments. So may I just proceed with the argument?
Yes, please.
Much obliged, your lordship. So, as I was quoting the judgment of the Delhi High Court in the case of MEB Infrastructure Developers Limited versus South Delhi Municipal Corporation, which upholds the single judge decision ruling that the appellant cannot use Article 226 to invoke writ jurisdiction, dispute should be resolved through the Contract Act and civil proceedings in the commercial courts in itself. The same has been contended in the case of Pratibha Nila versus State of Madhya Pradesh. emphasizing the need of the substantial evidence of fundamental rights infringe, which I just answered to the question of your lordship. And here the company's fundamental rights is not been breached, but instead the fundamental rights of the Toxo community has been breached, your lordship. As the Alpha private limited company has been used the traditional information which lies to the Toxo community for their own commercial gain without giving any credits to the Toxo tribe themselves. If your lordship is satisfied with the arguments of the issue 1, may I please resume with the issue 2?
Yes, but
Yes.
may I just request, if you go a little fast on the issues and hit the bullet points, no, we'll save time. You won't eat
Indeed.
away on your co-speaker's time.
Indeed,
no?
indeed, indeed, your lordship. I'll take that
Yes, please.
consideration. Your lordship, in the first instance, it is imperative to establish that the product in question does not qualify as an invention in itself. The product should fulfill the definition under the Patents Act Section 2, Clause J. An invention must be a new product or process involving an inventive step and not previously discovered or invented. Furthermore, it is a fundamental that the exclusive right to patent, such as invention, rests with the indigenous tribe responsible for its discovery. In this case, the Toxo semi-nomadic tribe. Regrettably, this exclusive right have been violated by the Alpha Private Limited, which fraudulently acquired knowledge about the Perry plant and subsequently created a product known as Novak. The Toxo community find itself
If they have done something fraudulently, why did you enter into contract with them? Did you not do due diligence?
Indeed, your lordship, but as I stated, the contract related issue that will be dealt with my co-counsel. But
No,
just to
because
give
you're
the
saying
gist of it.
fraudulently. Fraud is a very huge. It's got some very big ramifications. When you say fraudulently, there must be some.
Indeed, your lordship. But the Alpha company itself, they kept even the controller general and the government of Indiana into an illusion that they were the one who were the sole owner of this Novak medicine, that they invented this medicine from the scratch. They have never stated that forget about even stating that. They have not even given the credit to the Toxo tribe for this invention that I have just talked about. Your lordship, now may I please resume with the
Please proceed.
arguments. Much obliged, your lordship. Your lordship, getting into the legal perspective, Section 3 deals with the revocation of the patent on certain grounds. Consecutively, Section 3 Clause A and 3 Clause A stipulates that the patent should not be granted for invention contradicting established natural laws. This contention aligns with the Biological Diversity Act 2002, Chapter 2, Section 7, which requires prior interpretation to the State Biodiversity Board for commercial use of biological resources by the individual or entities of Indiana, your lordships. The same has been contended in the case of Center of Social Justice and others versus Union of India and others. Now coming to one of the most important clauses of Section 3, your lordship, Clause D, which asserts that merely discovering an existing natural form lacks enhanced efficacy. However, discovering a new form of a known substance or using a known process with a new reactant constitutes innovation, supported in the case of Golem Industries Limited versus Cadila Healthcare Limited. Most importantly, your lordship, Section 3 Clause P, which states that the traditional knowledge is known how the skill that are passed from generation to generation of a community and are already known cannot be patented. For example, your lordship, the antiseptic properties of the turmeric itself. In this, comparing that to the present matter in hand, the Novak medicine was derived from the Perry plant. And Toxo community from generation to generation have been practicing have been driving the medicinal properties out of the Perry plant, and out of nowhere, the Alpha Private Company Limited, without even giving them the recognition, or without even putting their the name of the Toxo tribe forward, they clearly infringe the fundamental rights of the Toxo tribe here, exploiting them left and right. If your lordship is satisfied with the both of my arguments of the issue, my co-counsel will go ahead with the issue 3 in
Yes,
hand.
please.
Yes.
Yes, please.
Much
Thank you.
obliged, your lordship.
Your Lordship, the council seeks permission to continue from where the council left.
Yes, yes, yes.
Please.
Much obliged, Your Lordship. Your Lordship, concerning about the cancellation of contract, the learner petitioners have forgot that they have not taken any prior informed consent from the indigenous people, nor they have.
But you also did not inquire about that. You're the state.
Your Lordship, on the grants of the patent, when the patent was granted, on that basis, we had considered that all the the procedure has been followed by the company, and on that grounds, we had thought of making a contract with the company. But after knowing from the Unnati NGO that whatever the facts of the matter were, we decided and announced in the conference that we won't be able to comply with the contract, and we will further revoke it. Your Lordship, this case hinges on safeguarding intellectual property, asserting that this belongs to the Toxo community and not the Alpha Private Limited. Your Lordship, many international conventions, case laws, and certain precedents express the same thing. Your Lordship, Nagoya Protocols Article 5 raises a debatable issue regarding the implementation of a mutually agreed terms. Your Lordship, when a company has to come into a contract or wants to take some knowledge of indigenous community, should actually have some mutually agreed terms on terms of merits and on terms of benefit sharing. These mutually agreed terms, as stated in the Nagoya Protocols, have not been taken into consideration by the Alpha Private Limited company while asking for patent. Your Lordship, one of the important cases, the Basmati rice patent dispute in India, underscored the contentious issue of protecting the indigenous knowledge in genetic resources. It questioned
That is
the
not in
patent.
dispute. None of that is in dispute. The question is, why did you not verify all this before entering into contract and arbitrarily cancel contract?
Your Lordship, we already, Your Lordship, with regards to that, Your Lordship.
See, the issue is of arbitrariness.
Indeed,
It's all
Your
right. You can, in your continue with your arguments, you can address it.
Sure,
How
sure,
your
Your
action is not arbitrary.
Much obliged, Your Lordship. Much obliged, Your Lordship. Your Lordship, one of the important reasons for the government to revoke the contract was when it was initially known about the Novak medicine, the company kept us in an illusion that the medicine is totally new. Secondly, Your Lordship, government contract was given on the basis that it will be for the betterment of the nation. But after knowing that if the patent that has been taken by the company was illegal and was arbitrary by itself, Your Lordship, the government had no other option but to revoke the contract.
No audio alteram partem principle where that it has gone. Audio alteram partem. No man can be condemned unheard.
Indeed, Your Lordship. Indeed, Your Lordship.
Yes.
With regards to that that contention, Your Lordship, I will submit some contentions from the state of Himachal Pradesh as a council of them, submitting that the contract termination with Alpha Private Limited aligns with the doctrine of public policy, safeguarding the public welfare and indigenous community of the traditional knowledge. Your Lordship, with regards to the Article 14, the Audi Alteram Patrum, again stating the same contention of my co-counsel that intelligible differentia, one of the most important concepts that states that if by any chance a state is working on public interest, can extend the jurisdiction of the Article 14. Your Lordship, there are two rational reasons for that. One is the rational relation and second is nexus. Nexus, Your Lordship, brings the connection between the basis of classification and objection of legislation. Your Lordship, with regards to the object of
No,
legislation.
that there is no intelligible difference here. So that you cannot apply that particular principle now.
Your Lordship.
How do you justify cancelling a contract in a press conference? See, somebody puts pressure on you, you cancel the contract. Obviously, the other company is having financial loss. They've lost face in the government, in public. They have to be compensated. That's why they have moved the court. How do you justify?
Indeed, Your Lordship, I will answer that question by stating that they have came to court for commercial purposes. We agree that they would have lost have suffered certain losses. But Your Lordship, the patent on the grounds for the government to to issue a contract was, Your Lordship, the patent. After knowing that the patent was taken misappropriately by the Alpha Private Limited, knowing that the knowledge was all about indigenous community, the government would have acted arbitrarily if the government under Section 102 of Patent Act have a lot of powers of taking the patent back from the company and issuing on their own name. But the government knew that this patent, the actual knowledge belongs to the tribal community, belongs to the Tokso tribe. And on that basis, we didn't do that. And Your Lordship, with regards to intelligible differentia, in the Praveen Singh versus State of Punjab, Honorable Supreme Court stated that arbitrariness opposed to reasonableness is an arbitrariness to law. There cannot, however, be any definition of arbitrariness, neither can there be any straight jacket formula evolved therefore, since the same is on the varying facts or the circumstances of each case. Lordship, the principle of equality does not pronounce the state from making differentiation between person and things, but such permissible classification must satisfy two conditions, namely the classification to be founded in intelligible differentia. Firstly, the most is rational relation, and secondly, there is a nexus. Lordship, this does comply with the present situation, Your Lordship, because a legislation which may be quite reasonable and rational at the time of the enactment may, with the lapse of time or due to change of circumstances, before arbitrariness reasonable and violative of such doctrine of equality, and same if it is found in the rational classification. Your Lordship, the council seeks extension of time.
Yeah, wind up in a couple of minutes here. Wind up if you can, huh?
Indeed, Your Lordship. Indeed, Your Lordship.
Thank you.
Your Lordship, with regards to the contention stated by the learned counsel with regards to doctrine of promissory estoppel, I will deal with that issue importantly. Your Lordship, in the Honorable High Court of Himachal Pradesh, the state of Himachal Pradesh submitted that it did whatever on the basis of doctrine of public policy. Your Lordship, referring to the case of Ratan Chand Hira Chand versus Aksar Nawaz Jung, it's highlighted that contracts detrimental to public welfare are against public policy. Similarly, the principle of promissory estoppel doesn't supersede the broader public interest, as evidence in the Century Spinning and Manufacturing Co. Limited versus Ulhasnagar Municipal Council. Your Lordship, the petitioner wisely manipulated the doctrine of promissory estoppel into their own terms. They have not contended the limitation of promissory estoppel. Your Lordship, the council seeks permission to refer to the D.D. Basu interpretation.
Yeah, go ahead.
Much obliged, Your Lordship. Your Lordship, there are 8 principles and 8 limitations to the doctrine of promissory estoppel. Your Lordship, the first one, there are 8 principles from which 3 have been violated by the Alpha Private Limited Company. Your Lordship, on that grounds, we have revoked the contract. It would be, first ground is, Your Lordship, it would be open to the public authority to prove that there were special consideration which necessitated his not being able to comply with the obligation under the doctrine in the public interest. Your Lordship, here, after the public outrage, after knowing the knowledge of Tokso community on that public interest, we duly revoked the contract. And secondly, Your Lordship, the
No,
second
you revoked the
contention.
contract because somebody made a protest.
No, Your Lordship, not just about the protest, but also about the Toxo community, because their rights were infringed after knowing that the government got to know from the Unnati NGO that filed the notice of post grant opposition, Your Lordship. And
Proceed.
much obliged, Your Lordship. The doctrine, the second contention is the doctrine cannot be invoked to prevent the government from acting in discharge of its duty under the law. Your Lordship, the doctrine of public policy is duly induced in Article 19, Clause 2. Your Lordship, 19 Clause 2 adheres the government to protect the public interest. And that concerned, we had revoked the
Article
contract
19(2) of the
Constitution.
Constitution.
Your Lordship, the Article 19(2) of the Constitution
But
deals
that is
with
a restriction on free speech.
Yeah.
not maybe the council.
Article 19(2) is only on free speech. Okay, proceed. You wind up your argument.
Sure, Your Lordship. May the council just wind up in 30, 1 minute.
Just wind up.
1
Yeah,
minute,
1
1
minute.
minute.
Go ahead. Quickly.
Much obliged, Your Lordship. Your Lordship, with regards to the promissory estoppel, the most important contention over here is that he over here in the present matter is the Alpha Private Limited company. He who seeks equity must do equity. They by their own self has not done equity to the Toxo community. On that basis, we can also contend that they are acting in an arbitrary manner and not the government, Your Lordship. And Your Lordship, with regards to the most important prayer of the respondent of asking the petitioner of asking the compensation in the case of Burma Construction was the state of Orissa, and second also in the case of Universal Imports Agency versus S Chief Controller Import and Export, it was contended that Article 226, a compensation or a decree of compensation cannot be granted except it involves an order of payment of money in pursuit of statutory obligation. Your Lordship, we duly agree that statutory obligation exists over here, but in both the cases, it was clearly contended that the claims of compensation is related to the refund of illegally collected taxes and the refund
Thank
of
you.
penalties.
All right. Thank you. If you can just wind up with your prayer, please.
Prayers, much obliged, Your Lordship, much obliged. Wherefore, in the light of the issues raised, arguments advanced and authorities cited, it is most humbly and most respectfully submitted that this honorable court may graciously be pleased to adjudge and declare that this honorable court dismissed the present writ petition on the ground of lack of maintainability due to jurisdictional issues. Secondly, Your Lordship, that the honorable court declare that the Novak medicine does not satisfy the requirement of patentability as per Section 3 of the Patent Act. Your Lordship, thirdly, the honorable court uphold the action taken by the state of Himachal Pradesh and the control of patents, asserting that the cancellation of contract was not arbitrary and does not warrant to compensation to the petitioners. And Your Lordship, lastly, pass such order that and further orders as this honorable court may deem fit and proper in the facts and circumstances of this case, and or pass any order, direction, or relief that the honorable court may deem fit in the interest of justice, equality, and good conscience. Your Lordship, the respondents would humbly pray the court to adhere the petitioners, the Alpha Private Limited, to give some compensation, some amount of benefit sharing and credits for the patent and for some benefit sharing with regards to the profits they have gained from the Novak medicine to the Toxo community, Your Lordship.
Thank you.
Much obliged. For this act of kindness, the respondents, as in duty bound, shall humbly pray, Your Lordship. Much obliged to the Lordships to listen to the arguments of the respondents. Much obliged.
Much obliged.
Yes.
Team 33, would you like to rebut?
Yes, sir. Your Lordship, may counsel be permitted to give rebuttal?
Only 2 minutes.
Much obliged, Your Lordship. Your Lordship, counsel would like to point out a few things, Your Lordship, on the arguments of the learned counsel for the respondents. Your Lordship, firstly, the last judgment cited regarding the monetary claim regarding Burma case, Your Lordship, that case was in 1961 and was overruled by the ABL International judgment, Your Lordship, and that is what the counsel had cited in order to ask for the monetary compensation itself. Therefore, citing a judgment that has no relevance here, is something that council believes it should not play any role in the judgment of this court. Further, Your Lordship, in the Supreme Court case judgment of Sri Sidbali Steels Limited versus UP, Your Lordship, the wording of the judgment about how fundamental rights aren't present for a company, this judgment had a similar wording but had the clause Article 19 to the end of it. The fundamental rights of the company are not applicable to the extent of Article 19. However, the next line of the judgment said any petition with Article 14 violation alleged by a company can be maintainable. So that contention of the respondents falls apart as well, and we will require some answering on that. Thirdly, Your Lordship, a few questions regarding what has been alleged. Clearly, that there's a lack of due diligence from the side of the government because they're alleging that all of it was on government or what was happening. We were working on the facts that were present at hand, considering the patent was granted, and that is why the contract was filed. Secondly, Your Lordship, clearly we could see that from the arguments of the arbitrary assertions in the arguments also, the government has no intention of following any principles of natural justice because they seem to be the judge in their own case. They seem to be determining that there has fraud has happened. This has happened, that has happened. A lot of things have been asserted by the councils, Your Lordship, none of which have been proven. There hasn't been a single ounce of proof or evidence that has been stated regarding the same. And they've alleged that we had gotten information from the tribals. But Your Lordship, in the proposition, it's clearly given that they had, if I'm not wrong, Your Lordship, they convinced the tribal people to disclose more info, Your Lordship. There was nothing regarding any false use of procedure or anything. And from this, we would like to contend that the respondents are trying to misuse the facts, misuse judgments, and mislead this court into delivering the wrong judgment. With that, counsel, much obliged, Your Lordship.
Okay.
Your Lordship, the Council of Respondents seeks for a rebuttal.
1 minute, 1 minute.
Yeah, 1 minute.
Indeed, Your Lordship, much obliged. Your Lordship, with regards to the compensation, we relied on two judgments: the Burma Construction and the State of Orissa versus the State of Orissa has been upheld, but the obiter dicta of the judgment is still on picture. Not even relying on that judgment, we also stated one more judgment, that Universal Imports Agency versus the Chief Controller of Import and Export. They contended the same thing, and it is still not upheld yet, and it won't be upheld yet. Your Lordship, with regards to other issue of 14, 19, and 21, the Council of Petitioners is clearly contending on Article 14. Your Lordship, Article 19, Your Lordship, Article 19 deals with only citizens of this nation. It's never contended that person, an artificial entity, has a right of violation, Your Lordship.
Yes, yes.
And here, with regards to evidence, Your Lordship, the council complete in 20 seconds, Your Lordship. Just one condition.
Say quickly and finish.
Much obliged, Your Lordship. Your Lordship, with regards to new evidence, Your Lordship, we got the new evidences after knowing that the petitioners, the learned petitioners, have not disclosed any information to the patent controller and nor to the government. On the basis of that, we have revoked the contract later on. Yes, Your Lordship.
That's all? Okay.
Much obliged, Your Lordship.
Okay. Yes.
Yes, I think participants are done with the arguments.
Okay, completed. Yes.
All right. Yes, sir. If judges have no further questions, we can declare the conclusion.
Yes.
All right. Yeah. Thank you, sir. I request you to please fill up the score sheet and send it back if convenient, so that we can quickly start with the validatory session immediately.
I'm just sending the score sheet.
Yes, sir. Yes, please.
In the meantime, I think we can start with the validatory, I think. Because
Definitely,
we'll send the
sir.
score sheet. Yeah.
Yes, sir. Yes, sir. Yeah, participants, please stay connected. We are about to start the validatory session in a minute. Yes.
Lordships.
Yes, participants, Lordship will be giving their feedback in the validatory session. We have given them time to speak, so they'll be giving their feedbacks in the validatory. Yes. Yeah. And just stay connected. Okay. You can switch off your videos for a while. As soon as we start, you can switch it on. We'll just take another 3 to 5 minutes for it to start. Not more than that. Yeah. Don't leave the session. Okay.
1 minute, sir. Why, sir? 1 minute, I will
Yes, sir,
come
yes,
back.
sir. Yes,
One
sir. Please,
minute,
sir.
I will
Please,
come
sir.
back.
Yes, of course, sir. Please, sir.
Not an issue, sir.
Yes. That through WhatsApp that I have sent that marks list, score list. Okay, 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 okay. Okay, 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 okay.
Yes, I think we'll start with the valedictory session.
Yes, please.
Yes. All right. So, the convener, will quickly start. Yes, Amit sir.
No, I think Naidu sir is not on this thing. I think his
Yeah, yeah.
video and
That's what.
yeah, okay.
We'll just wait for a minute. All right. Yeah.
Yes, sir.
Sir is. Yes, sir. Yeah. We can calculate in the meanwhile. Till then, we can start so that we can give a very quick feedback to the participants and all. Yes. I request all the participants to please keep yourself on a mute so that we can hear the judges. Right? Yes.
Anita's done.
Yes. Anika, please start. Yes.
I think Patil sir and Naidu sir can give their feedback, then I can
Yes.
chip in.
Anika, can we quickly start?
Yes, ma'am. I hope I'm audible.
Yes, you are. Yes.
A very good evening to all, and a warm welcome to the distinguished guests, esteemed faculty members, and our talented participants. On behalf of the School of Business and Law at Navrachana University, I welcome you all to the valedictory session of the Navrachana University Second National Moot Court Competition. On this momentous occasion, I am reminded of the words of Howard Cosell. The ultimate victory in competition is derived from the inner satisfaction of knowing that you have done your best and that you have gotten the most out of what you had to give. We have finally arrived at the final step of the second National Virtual Moot Court Competition 2023. It has been a pleasure and honor to host this event and witness the dynamic arguments by all the participants. The competition has been cutthroat right from the beginning. All participants have displayed excellent mooting skills. We received an enthusiastic participation from 44 different teams from reputed law institutions across the country. Through rigorous evaluations in preliminary and semi-final rounds, 2 teams were selected and the final round was conducted. We will be declaring the winners very soon. But first, I would like to welcome all our esteemed guests and judges. I would like to take this opportunity to thank all of you for gracing us with your presence on this special occasion. To begin with the event, I request Dr. Sujata Patil, Principal of Law Program at Navrachana, to please share a few words.
Thank you, Anita. Yeah. Am I audible?
Yes, yes.
Yes. On behalf of School of Business and Law, Navrachana University, I take this opportunity to welcome our distinguished guest for the today's valedictory function, and they are the one who judged the finals also. I take this opportunity now to welcome the former Judge of High Court of Karnataka, Justice B.A. Patil, and presently a Chairman of Karnataka Grabbing Prohibition Special Court, Bangalore. Welcome you, sir. And I also take this opportunity to welcome former Judge of High Court of Karnataka, High Court of Telangana and Bombay, Justice Naidu, sir. Welcome for the today's valedictory session. And I take this opportunity to welcome Advocate Amit Pai, who has been associated with us since from the long time. Welcome you, Dr. Amit, Advocate Amit Pai. And on behalf of I take this opportunity even to extend a warm welcome to all the participants from across the country who, showed an interest in taking part. And since from 2 days, we are noticing the way they are put forth in their arguments and the way the enthusiastic they are showing. And I welcome all the participants for the today's valedictory session, all my faculty colleagues and students. Well, as we all know that since from yesterday, we are just running out with this journey. What I noticed is that the kind of preparation, participation is one, and the kind of preparation that the student have done, it is commendable. Yesterday, when I had been for I just chaired a couple of sessions of the preliminary round. What I noticed based on their argument is that the students are very much thorough with the facts, knowledge of law, and this shows that the kind of research that they put for this competition. So my big applause to all the participants who participated in this event. Winning and losing is the part of the game, always. But taking part is more important. And that is how you are going to learn. And you're going to inculcate a lot of skills that is required for the law professional. And Mooting is such a platform which provides a lot of benefits for the student, and which I also shared during an inaugural session. So with these few words, one thing I wish to, even we are very much proud and we feel pleasure that this is our second national moot court competition, and the first one last year when we hosted it, we had an average in number. I can say that a few in number participated, but this time it's a huge number of students, a team across the country participated around, as Anika mentioned, around 44 teams participated. Really, we feel it is very, very proud moment for us, because a good in number as participation always have a good spirit and the good competition. And now, looking at the way the student has participated in this year, this clearly indicates for us, or we feel that it's better to switch over from online to the offline. I think the kind of crowd, the kind of responses that we are getting, it's the second national moot court competition, but we received a very huge response from the student. So always physical is one advantage for all the students, that is they'll get an opportunity to explore networking with the students, within the law fraternity, and also interacting with the judges. This is the best part for the student. But anyway, due to the pandemic, and also due to that, we are at the initial stage of hosting this national moot competition. So we begin with the online, but soon we are going to have the offline also. With this few note, and I also, again, my appreciation goes to all the students who made a put forth their tremendous efforts. And when it comes to the putting their argument, or if you look at their research work, really a round of applause to all the students. And I don't take much of your time, because now we are all waiting to hear a few words from all the distinguished guests of today's event. And also students are very much awaiting to see their results also. Now, with these few words, I end my speech. Thank you for giving me this opportunity.
Thank you so much, ma'am, for your kind words of welcome. I would now like to welcome a distinguished guest, Justice B.A. Patil, Chairman of the Karnataka Land Grabbing Prohibition Special Courts and former judge of the High Court of Karnataka. Honorable Justice B.A. Patil obtained his law degree from the University Law College, Dharwad, in 1983. He enrolled as an advocate and practiced in Karnataka. Sir was a gold medalist in his LLM and also worked as a part-time faculty member in various law colleges across Karnataka. Sir was directly selected as District and Sessions Court Judge in the year 2002 and has also been honored with the Aryabhatta Award. Sir has assisted the Committee on Reforms of Criminal Justice System. Sir was elevated as Judge of the High Court of Karnataka on 14th of November 2016 and became a permanent judge on 3rd of November 2018. Thereafter, Sir was appointed as a one-man commission of inquiry to inquire into the circumstances and events leading to the death during the COVID-19 pandemic. Sir was also appointed as Chairman of Selection Committee of Karnataka Electricity Regulatory Commission. Sir is presently working as a Chairman in the Karnataka Land Grabbing Prohibition Special Court, Bengaluru. It is my pleasure and privilege to welcome you, sir, and I invite you to please share a few words.
So, good afternoon to one and all. my esteemed brother, Justice D.S. Naidu, and Shri Amit Pai, Advocate, Supreme Court of India, Dr. Sujata Patil, Associate Professor and Principal of School of Business and Law, Navrachana University, faculty members, and dear students who have taken strain to participate the second national moot competition. So just now that we came to know that 44 teams participated in this moot competition. Within a span of 2 years, getting 44 teams in participation for the national moot is considered to be a tremendous achievement. I congratulate the university for having made all the efforts and achievements. And I also wish all the best of luck in future to their all endeavors. So my friends, that this legal system has developed to do justice. Theory underlying the administration of justice is the best means of finding out the truth between the two contending parties is to hear each side through skilled advocates and to entrust the decision to the impartial judge capable of weighing the arguments of both the sides. So whatever has been said, it appears to be very true. Today, though they are not the advocates, I will use the budding advocates. They argued well. They have done their job with well preparation, well submission, and even whatever the queries so which have been made, they have answered to their best ability. My esteemed brother Naidu may agree to me, and even that is Pai sir may agree that even the arguments so which have been advanced, it is defeating to any other senior advocates. So I congratulate them. So even though both the sides have done a good job, so whenever it comes to the competition, it is very difficult. Writing a judgment to a judge is very easy. But to weigh the arguments of the both sides and to give a decision who is the winner is a very difficult task. If two prizes are kept for first, then I could have given to both of them. But I think that is first and second has to be selected. So here that we three that is we have that is concurred to one that is team, and that one will be winning team, and the another one will be the second. Now I will not say that he is the loser. So here that winning and losing, as Madam pointed out, is the part of the game of an advocacy. So here, except in mediation, so here both the parties will not win anywhere. So that's why that merely because you have put in as second, so here don't be, that is, under the impression that you have not done well. So it is a stepping stone for your future to come up in that your life. So my friends, the problem, so which has been, that is mooted, is also very well framed, well designed, and it has been made as an arguable. Sometimes that I have attended many moot court competitions, so it will be one-sided. So other side that there will not be any material. But this moot problem is very unique, and it is arguable on both sides, and both sides are having that is points for the purpose of this. So here always the success depends upon the preparation. So here preparation, and apart from preparation, so here that it has to be well planned. That's why it is said, I quote, winners do not do different things, they do things differently. So here that when Pai sir has put some question to both the sides that I was observing, so the way in which the answer is given by both the sides, that it was amazing. So that is how the skill lies with an advocate. So always, no lawyer wants to lose the case, but he makes all the efforts to see that he must win the case. So that's why that you have prepared well with the facts, documents, decisions, and you have proved that your talents. Apart from that, both the teams are having convincing capacity. Many cases fail in the court because the learned counsel is not capable of convincing the queries of a judge. Or sometimes that the cases are also going to be failed because of a seriousness of a, that is, advocate. He will not, that is, even, that is, laugh at the judge. So that's why that the advocate must have a special preparation. Apart from that, he must have a good humor. So here in that is participating in the courts. So here that lawyer must work hard, and he must have a devotion to his duty. It is always said, a successful lawyer leads a strenuous life. So here that that is going to quote one instance of, that is an learned advocate from Bombay. His name is Bolabai Patel. He was an eminent lawyer. He was a junior, and he was going towards a court hall to argue a case by holding the notes in his hand. His senior came in front of him and asked, what and where you are going? So then he said that I am going to argue a case. What is there in your hand? He said, notes are there. So immediately he took the notes, and so he tear it out, and then he asked him to go and argue the case. So here, little bit that this particular, that is a junior counsel, disturbed, but anyhow that already case has been called out, and he went there. So here that he has so well prepared without notes, and he submitted all the things, and the judge appreciated, and the case has been decided. So thereafter that he pointed out that without making a notes, I have to go to the court and submit. That's how. So here the preparation must be there to a advocate. So here that one more, that's the instance I quote, and I will close my speech. An eminent lawyer has been called to a school function. After the function and the speech of the lawyer, a girl in the said school stood up and told, "Lawyers are liars." The learned counsel shocked. He was a senior counsel. So then he asked her why she is telling like that. Then she said, "So last week, a case has been acquitted in a criminal murder case. I was the witness in that. I was an eyewitness. I have that is deposed before the court, and you are the defending lawyer. So even in spite of my telling that the court has acquitted him." So then a wise liar, he said that I have not lied anything. What I have done is that I have only established the fact that the prosecution has not proved its case, not proved the guilt of the accused. So here, that what I wanted to convey by virtue of this illustration is, so here, that it is an intellectual submission made by the advocate to the girl. So she was convinced. So here, in this way, that is, the lawyer must have a knowledge. Knowledge is considered to be power. Apart from knowledge, he must have a wisdom and sympathy towards the people. So here, it is a crowning factor to that said incident. So therefore, that I pray that you become a good lawyers, and you must also have a wisdom, and you be successful. Always no, that is no lawyer will be success in all the cases. So here, that losing, that you have to take as it is, and so prepare well, and come forward and help the people. And apart from that, that the lawyer's duty is, so here, that social reform is also the duty of a lawyer. So here, that whenever the social cause comes, that is today's problem, so it can also be taken into a social problem. So in that way also, so here, that a duty cast upon that this particular, that is a lawyer to defend such cases. And I advise you that maintain the morality, learn the law like Ekalavya, and apply the law like a Arjuna, and win the case like Dharmaraya. So that is how that these three principles must be adopted in your, that is a future career. I wish you all the best. And I also thank especially Sujata madam and all the organizers for having given me this opportunity to participate in this moot competition and to share my few thoughts. And I also thank, so here, my esteemed brother D.S. Naidu and Amit Pai for having joined with me. Thank you very much, sir.
Thank you, sir, for your encouraging words. Next, I would like to welcome Justice D.S. Naidu, Senior Advocate at the Supreme Court of India and former Judge of the High Court of Bombay. Sir graduated from Andhra University, Visakhapatnam. After graduating from Andhra University, Sir obtained a law degree from Sri Venkateswara University, Tirupati. Then after, he enrolled as a member of the Bar Council of Andhra Pradesh in March of 1997. Sir has practiced in civil as well as criminal areas in the District Court of Tirupati and the High Court of Andhra Pradesh, during which he has represented many renowned corporate entities, nationalized banks, apart from private clientele. Sir was associated with the AP Judicial Academy, Hyderabad, as a guest faculty and has authored several law books. Sir was elevated as Additional Judge of the High Court of Andhra Pradesh on 21st of September 2013 and has also served as a judge at the High Court of Kerala and the High Court of Bombay until 2021. It is my honor and privilege to welcome you, sir. I invite you to please come forward and share a few words of wisdom.
Thank you very much. Honorable Sri Justice B.A. Patil, Chairman, Karnataka Land Grabbing Prohibition Special Court, and also a very renowned former judge of High Court of Karnataka, and my dear friend and never say no character called Amit Pai, and Madam Dr. Sujata Patil, Principal of Law Program, School of Business and Law, Navrachana University. Then Madam Nidhi Jain, Assistant Professor, and Madam Madhura Tombre Kulkarni, Assistant Professor, and all the young and ebullient fellow students, apart from the other faculty of the university. I've been indeed privileged to be amongst you today. And of course, that a bit disturbed my holiday, but it's well worth getting disturbed. And we sat as a full bench to decide. I don't know how we decide, but we certainly, all three of us, with humility, could say on their behalf as well, we have learned something from you. The way you strive to convince us, the way you strived to live up to the expectation. Every day we all learn, that we don't forget. And as part of this full bench, I've got two options before me. One is simply endorse what my learned senior has said, because I couldn't agree more. What he has said, you all feel that he has told and you have learned. In fact, I too have learned. I have noted down some of the points he has said out of his rich experience. And that's why I have my first option is, I could have simply said, I concur. And I do concur.
Yes.
Signed, finished. Then, though I concur, I could as well add a couple of comments. So a concurring judgment, adding some additional reasons so that whatever has already been there, though I can't paint lily white, but still I'll strive to add something to my learned senior brother's comments. You know, when I've heard the articulation by the young participants in the competition, I've just observed something. You know, you tend to, because you may not have much exposure in the real-time advocacy field, that's why you tend to be in a copybook style. No, when I've noticed, whenever we put a question, rather, of course, that was done by Amit and we were just watching. And whenever we put question, the student would respond, the contestant would respond, much obliged, much obliged, much obliged. Yes, you can as well do that. But you know, variety is the spice of life. Try to add different expressions to that one instead of being monotonous, right? Then, when it comes to narrating the facts, please remember, we all say, your lordship knows. I don't know how far lordships know, but the question is, the lordships may know law, but not the facts. You are the master of the facts. That's why, when you narrate the facts, please imagine the judge is ignorant and proceed from that perspective. And also, when I was on the bench, I was telling every young advocate, don't tie yourself in knots. Simply tell a story. We all believe in stories, and advocacy is nothing but telling a story. Whoever tells a better story carries the day. Please remember, this is the bottom line. Advocacy is nothing but storytelling. Please tell a story and you win the day. Then, the second concept, as I call it, the curse of knowledge. You know what happens? A client comes to you, once you become a lawyer, of course, and he briefs you. Then you draft it. Then you finalize it and you file it. Thereafterwards, you go through all your pleadings, the documents. By the time the matter comes to trial, it's become second nature to you. You have just completely internalized the facts and every surrounding circumstance of your case. And the curse of knowledge is that you also imagine even the judge is equally familiar with the case as you are. That's why most of the times advocates start in the middle, as if the judge knew. Please remember, the judge did not know. That's why you have to begin at the beginning and then continue your story. That's how it goes. Then I have observed, whenever you argued, you have said the council breaks down the issue into this and what the council contends. See, please humanize your arguments. This humanizing means be conversational and say, I don't feel shy of that one. It is you who has been articulating before the court, right? I say, I break the points into this, rather the issue into these things, or I articulate, I suggest, I submit this way, that way, instead of in what you call a third party narrative like the council, right? That's why be human, be personal is my request to you. And essentially it amounts to being conversational is quite always a good thing. And as it's been pointed out by Mr. Amit Pai, he said, better just set out your points, show the roadmap to the judges, and then cover each aspect so that we can easily follow you, right? That's another thing you need to have for having an effective argument. It's always good for you. And of course, one counselor said, I have got 4 reasons, rather 4 points to articulate. When it comes to cognitive psychology, earlier people used to believe a brain could master or remember 7 facts at any given point in time. Now it has come to 3. And you have seen some of the very famous judges in Supreme Court as well. They will say, my lords, I have got 3 points to submit. Of course, they say they submit 30, but they begin with only 3. Correct. This is one psychological factor. Now, psychologists say that always begin with 3 and do whatever you feel like. This is another important thing that I've noticed. Then, my request to you all is that don't invent the wheel. You need not invent the wheel. It's already been invented. So make use of it in an effective way, perhaps in a better way. And advocacy, the whole of legal profession for that matter, is nothing but imitation. Now we have got a wonderful opportunity of watching every seasoned advocate, say in Supreme Court, in any, for that matter, any other high court. And also, for example, the UK Supreme Court. You go to UK Supreme Court website and click on any decision, you will get the judgment and also the arguments of that particular case. So that way, kindly watch all these seasoned people. Right? Once you watch these people, you certainly will come to know the effective way of advocacy. This is how I say that don't invent the wheel, but certainly you can gain from the experience of all these stalwarts. And recently, last couple of weeks, I've been reading one very good book by Mehdi Hassan. You must be aware of Mehdi Hassan, now a journalist, earlier an Oxford debate champion. He has written a book called Win Every Argument. Win Every Argument. Please read that book. It is full of good practical suggestions for advocates. You will stand to gain from that one. That apart, if you feel like reading another book unconnected with law, young lawyers, I would like to recommend to you a book called Checklist Manifesto by Atul Gawande, a surgeon of Indian origin, rather Indian parentage, but an American. He has written a wonderful book, unconnected with law, but you tend to gain quite a lot out of it. That's Checklist Manifesto by Atul Gawande, right? Please, reading makes the man, as Francis Bacon has said. Don't stop reading. Don't stop learning. The moment you do either, you stop growing. And growth is a sign of vitality and life. And I am really grateful for the management of the college for having this wonderful opportunity. I look forward to another opportunity to be amongst you. Thank you very much.
Thank you, sir, for sharing your knowledge with us. Moving forward, I would like to welcome another distinguished guest, Advocate Amit Pai, Advocate on record of the Supreme Court of India. Advocate Amit Pai, sir, graduated from the IILS Law College, Pune in the year 2010. Sir has been the winner of several prestigious national as well as international moot court competitions and has also been actively involved in training law students across the country for mooting skills since his college days. After graduation, Sir enrolled with the Karnataka Bar Council for practice. Amit Sir has had the wonderful opportunity to work as a law clerk with the then Supreme Court Judge, Justice H.L. Datta, in between 2010 and 2012. Sir has also worked in the office of the Ministry of Information, Government of India, in between the years 2013 and 14. Since then, he has been in active practice at the Honorable Supreme Court of India, the Delhi High Court, and several other tribunals in Delhi. His excellence in the legal field has earned him the prestigious position of Advocate on Record in the Honorable Supreme Court of India in 2018 at a very young age. Sir has been extensively invited for expert talks on variety of topics in the field of law across the country. We are truly honored to have him with us today as a judge for the final round of our moot court competition. And I would like to extend a warm welcome and invite you, sir, to please share your thoughts with us.
Thank you very much, Justice Patil, Naidu sir, who I always look to for guidance, Dr. Sujata Patil, and my other colleague. So I've never won an international moot court, firstly. My bio is a little deceptive of what I actually am. Firstly, I want to congratulate all of you for having put up such a good performance. Not just today, I'm sure you have put up a good performance through, and therefore you are here in the finals. Like Justice Patil sir said, winning and losing is a part of the game. I would rather lose all my cases in moot courts, so that I can really win them in real court. So I'm just going to give you some sort of feedback because after two distinguished speakers have given you feedback, there's very little left for me to say. One of the reasons why I am more talkative than the other two judges is because I'm still a lawyer. Both of them have judicial temperament. I'm a lawyer, I have only talking temperament. That is why I ask you questions, but questions are asked only for one reason. They are asked to get, elucidate answers. Sometimes when we are doing a moot court, we end up with a prepared script, with a prepared, lines to say. That may not be how it is in real court. In real court, it is like Sir said, a narration as such, and a narration of a story, narration of a proposition. It is more of a discussion with the judges. Therefore, one of the reasons why you are asked questions, and the other reason why you are asked questions is also to put you off track, to see how you come back on track. And that's one of the things that I saw. All of you are able to come back on track. One or two quick points which I want to just before I conclude. What Naidu sir had just referred to, we keep referring to ourselves in third person. The council wants to say, the council, it's absolutely not necessary. Because when we go on saying the council, sometimes, you just get into that, the whole, it becomes some sort of unreal sense of talking. Nobody talks like the Amit wants to speak to you or the so-and-so wants to speak to you. Nobody talks like that, right? The second thing is, I think you are over-relying on case law, right? All of you. I want to give you this feedback because it is more important to understand a proposition in its true sense and back it up with a case law. Right? It is more important because then the proposition of law, what you want to argue, is what comes out. Then you relate your facts to the law and put across your case. The case laws are, case specific. It may be applicable for case A. It may not be applicable for case B, right? And once you get into case laws, I'm not saying don't use case laws. Case laws are extremely important, but do not ever ignore first principles of law. The bare text, what the text reads, how you understand it, how you apply it to the facts of your case. Then you back it up with case law. That's how you improve your advocacy. Let me just tell you one or two things about, what just Naidu sir was saying, begin at the beginning. This is something that happened to me. We in the Supreme Court sometimes start arguing from the middle, like sir rightly pointed out. I was arguing before the National Company Law Appellate Tribunal, at which time my normal way of arguing in the Supreme Court would be to begin from the middle, which is what I did. Since it was virtual, I overheard the senior judge tell the junior judge, he said, look at this fellow, he doesn't even know that he has to tell the facts. So I quickly corrected myself and then I started from the beginning. So the reason why I'm telling you this is, you have to narrate the facts as they are for your case. The fact sheet everybody, would have read. The facts as you tell them. That is what is important, because that's how you're going to substantiate your case. Apart from this, I think Naidu sir has rightly pointed out the importance of reading. One of the most distinguished lawyers in our country, Dr. Abhishek Madhu Singhvi, he begins like this, like Naidu sir said. He begins like saying, I have 3 points, or I have 2 points, or I have 4 points. Then he says 1. Then he says 1.1, 1.2, 1.3, 1.4. Then he says 2. Then he says 2.1, 2.2, 2.3, 2.4. Right? When you lay down the case, the focus of the judge comes to what it is that is going to be argued. Perhaps over a period of time. And now there is something that is extraordinary, which we never had as students. I never had as a student, and certainly my seniors never had as students, which is live streaming of certain matters. You can actually see, especially constitution bench cases, you can actually see the best lawyers in the country argue and explain propositions of law. Obviously, I'm not saying that you must argue like them, no. But what you can do is, by watching, you learn. And this is a profession that you learn by watching, right? So overall, I want to congratulate all of you for your effort. And I want to congratulate the university for conducting this. And thank you very much. One last thing, yes. When you argue, you don't say things like, yeah, I think somebody said info. No, you have to give full. These are all informal usage, right? We don't say these things. You say information. You don't say yeah. Sometimes you get pulled up by judges for saying things like yeah, right? So that's just about language. So thank you very much, and all the very best for surely a very successful career. Thank you.
Thank you, sir, for sharing your expertise with us. Now, let us move on to the most awaited part of the competition, that is the declaration of results. First, I would like to congratulate all the participants for putting their heart and soul into this competition. We salute your hard work. We will now be announcing the results and will be giving away 4 awards. The winning team will get a cash prize of rupees 10,000 along with trophy and certificate. The runners-up team will get a cash prize of rupees 7,000 along with trophy and certificate. And we will also be giving a cash prize of rupees 4,000 to the best mooter and the best memorial respectively, along with the certificate. Now I invite Ms. Nidhi Jain, Assistant Professor at School of Business and Law, Navrachana University, to declare the results.
Thank you, Anika. So now, the most awaited moment of any competition. A very good evening to the distinguished judges, talented participants, my fellow faculty members, and a very, very hardworking student volunteers. I, Nidhi Jain, on behalf of Navrachana University, delighted to announce the result of this second national virtual moot court competition. So after intense deliberation, rigorous evaluation, our esteemed panel of judges reached to their verdict. So without taking much time, the best memorial award goes to the team IILS West Bengal. Lots of congratulations to the team. Now, second award for the best mooter goes to the University NMIS Hyderabad, Harshita Kurupat. Lots of congratulations, Harshita.
Thank you so much.
Now, the award for the runner-up team and the winner team. The competition was very, very tough, and it was very difficult for us to decide for the winning team. In regard with the marks as well, it was very hard to decide for the winning team, and the difference of the marks was hardly 3-4 marks. But as this is a competition, we all know that we will have to decide for the winning team. So the runner-up award goes to Sri Jayantilal H. Patel Law College, Mumbai. Lots of congratulations to the winning team.
Thank you so much. Thank you so much, ma'am.
Now, the winner of this competition, award for the winner of this competition goes to School of Excellence in Law, Dr. Ambedkar University. Lots of congratulations to the winning team.
Thank you. Thanks a lot.
I would like to extend my heartfelt congratulations to the winners and to all the participants for their outstanding performances. Thank you so much for showing your interest and enthusiasm in participating in our second National Moot Court competition. We will look forward for your further participation in future events as well. Thank you so much and lots of congratulations to everybody.
Thank you, ma'am.
Thank you, Nidhi ma'am. Heartiest congratulations to all the winners. I would now like to request Madhura ma'am to deliver the vote of thanks.
A very good evening to all the dignitaries, participants, and the students. On behalf of School of Business and Law, Navrachana University, myself, Madhura Thomre, Assistant Professor of Law, is here to present a formal vote of thanks at the valedictory session of Second National Virtual Moot Court Competition. I would like to extend a deepest gratitude to Justice B.A. Patil sir for sparing time from his very busy schedule and gracing the occasion as a distinguished judge in the final round. Thank you, sir, for your words of wisdom, and we look forward to a lasting professional collaboration with you. Thank you, sir.
Thank you.
I would also like to extend a very sincere gratitude to Justice D.S. Naidu, sir, for accepting our invitation and for gracing the occasion as a judge for the final round. Thank you, sir, for your valuable presence, precious time, and most valuable inputs. And we definitely look forward to deepen our collaboration with you, sir. Thank you.
Thank you, ma'am. Thank you.
I'm literally short of words to extend my gratitude to our another distinguished guest, Advocate Amit Pai, sir. We all have seen the zeal, enthusiasm, and the rigorous test to which Sir put the mooters to, due to which we get to witness a very beautiful intellectual stimulation of young minds in the moot court competitions, especially in the final round. I'm sure the participants must have got to learn a lot in this short span of time from him. I'm deeply thankful to you, sir, for all the assistance that you always provide, your precious time and highly valuable inputs that you have given today. Thank you very much, and we look forward to a lasting professional collaboration.
Thank you.
I'm deeply thankful to our Provost, Professor Pratyush Shankar sir, Registrar Dr. Sandeep Pasant sir, our Dean Dr. Hitesh Bhatia sir, our Principal Dr. Sujata Patil madam, for trusting us and giving us an opportunity to organize this grand event. The event wouldn't have been successful without the support of all my faculty colleagues, and I'm deeply thankful to each one of them for their assistance. This second national moot court competition is a grand success only because of the tireless efforts put in by our student volunteers. We are really fortunate to get a dedicated and a very motivated team of student volunteers with us to manage the whopping number of 44 teams participating from different law institutions across the country. A lot of midnight oil was burnt, and I'm deeply thankful to each one of them for all the magnanimous efforts that they have put in to make the competition a grand success. We were delighted with the enthusiasm shown by all the participants, without which the organization of the event wouldn't have been possible. And thank you for your zeal, enthusiasm, research work that you have put in. And I'm congratulating all the winners over here. Right? I'm thankful for all the admin support that we have got in terms of organization of the event. Thank you, everyone, for being here, for sparing your time and gracing the occasion to make this event a grand success. I declare that the validatory event is concluded over here. Thank you, everyone. Participants will get further set of instructions from the student volunteers very soon. Thank you so much, sir.
Thank you.
Thank you. Thanks to all. And thanks to Madhura who coordinated the entire competition along with the court committee. Thank you, Sabra, all faculty colleagues. Thank you.
Thank you, sir.
Thank you, sir. Yes, we all can leave the meeting. Participants, many congratulations to all of you. You'll soon get the set of instructions from our students. We'll be releasing the score sheets and all just in a span of a few days, right? And kindly await for a few days to get the certificates, right? Yes. Thank you so much. Congratulations to all of you, each one of you.
Okay.